So today we're going to finish up week 2 or unit 2 with the arrow case, and then I'm going to get into unit 3. I posted a lecture outline for you on that. I apologize again for missing class last week. It's not going to be a habit, I hope, but I get migraine headaches pretty bad every so often, and I don't really ever know exactly when they're going to hit. And so last week I tried to let y'all know the night before rather than the morning of, because I don't ever want anybody to show up and then have to leave or come all the way over here for nothing. So I will combine last week's quiz with this week's quiz. So units 2 and 3 will be together, and they'll be due next Monday night, the 8th. You do not have any extra reading for week 3, for unit 3. It's just the outline and the key terms. No case this week, nothing, no articles, nothing extra. Also mentioned to you, I think I posted that I might, to be on the lookout for me posting a career preparation assignment. I want to explain why I've confused you about that. I haven't posted it yet because, let me explain why we do it. So the business school wants every business student to go through some career prep to include getting your resume updated, preparing for interviews, doing a practice interview, getting like your LinkedIn and all that stuff all up to date and spiffy. And in the infinite wisdom, the powers that be decided that was going to be part of the business law curriculum. So it falls to me to get to assign you some of this career prep work. It's a semester-long assignment. You can do it at your own pace. I haven't assigned it yet because the Center for Career Design, I don't know if any of y'all have ever had any dealings with them. They underwent kind of a reorganization, refresh over the spring and summer. And so a lot of the links and the materials that they gave me for this assignment, I've got to update them, and I've got to figure out exactly how they want me to, like you used to go online and reserve a time to do a mock interview with them. That's changed in the way that they do it. So I've just got to, they told me to hold off, basically, is what I'm telling you. They told me to hold off until I could run by everything by them and make sure that it's the way they want it before I give you the assignment. So I apologize for mentioning it last week and then not doing anything, but that is coming. It's not hard. It is important. It doesn't have much to do with business law, but I do think it's a worthwhile exercise for you to do, and we'll do that throughout the semester. So stay tuned for that. The only thing you have to worry about for this week is a quiz. It's due Monday over week 3, unit 3, lecture outline, anything to set in class, and your key terms. And it will also include last week's key terms, lecture outline, anything set in class, and the Arrow toy store case, which we're going to do in a second. Have I thoroughly confused anybody on that? Are we all good? Everybody's good on that? Okay. Excellent. So pull up, if you will, the Arrow toy store case. And I will kind of set the table for it by reviewing what we talked about last week. So last Tuesday, we talked about the idea of jurisdiction, and that refers to the power of the court over the parties that come before it. The power of the court to hear a case, both subject matter and also the power over the people who are in front of it. Jurisdiction. And we talked about how one state can exercise jurisdiction over residents of another state if that non-resident has done certain things in the other state. And the example that we looked at was that computer salesman in Colorado, I think, who sold a refurbished laptop to our student in Atlanta that was defective, that caught fire and burned her apartment down. Y'all remember that? And we talked about how things like a long-arm statute, which every state has, allows a state to exercise jurisdiction over non-residents by reaching out with their long arm, bringing them into court in the other state. so long as some requirements are met. If the out-of-state non-resident has very few contacts with the other state, but the lawsuit is related to those few contacts, then it's likely they could be subject to jurisdiction. If a person who's from out of state has an expansive set of contacts, does business here, has an office here, lives here half the year, that kind of thing, the more likely they are to be subject to jurisdiction, not just for what they do in the state, but for anything else as well. Right? That was the idea of long-arm jurisdiction. The purpose of today's case, as with most cases that we read, is going to be to take you through how a real-life court has addressed a real-life situation that comes up in this context. And also so that we continue practicing our legal literacy, using the right terms and phrases and words like that I want you to be fluent in. The other good thing about this case is that you get to see how the court takes you through their thinking and how they deal with prior cases in this area. How this particular court takes pains to take you through the history of how long-arm jurisdiction has been interpreted over the years, from the past to the present, and then at the very end of the case, they will apply the law to the facts of this case and tell you where they come out. So that's the setup for today's discussion on Arrow Toy Store versus Greaves. All right, so let's start off with the parties. Seth, tell us who the parties are to the case.
Arrow Toy Store.
Okay. Excellent. Who is Mr. Greaves?
Purchaser of a car.
Purchaser of a car. What else do we know about him?
Georgia.
He lives in Georgia. What do we know about Arrow?
They're not based in Georgia. They sold the car. I believe they're based in
Florida. They're a Florida company. Good. All right. I'm sorry, go ahead.
They're very large.
They're very large. How do you know they're very large? Yeah, they did $550 million in revenue. I don't know if that was over a 2-year period or 1-year period, but that's still pretty large, in my opinion. What about Arrow's setup, Seth? Business setup. What's their presence in Georgia?
Very minimal. They've only done 2 sales in that period of time.
Okay, only 2 sales in 2 years.
Very small percentage of the revenue.
Okay, small percentage of the revenue. What about their offices, employees, agents, things like that? Nothing in Georgia. Okay. All right. So tell me then, Drew, how did this sale go down? How did Greaves come to own a car that he bought from Arrow?
Well, I remember he was discussing with like some type of agent or something.
Yep, he was.
I can't remember exactly how he did that, but I remember he like went through the process and
Okay. Did he show up at their dealership lot in Florida? All right, Miss Upshaw's going. She's going to take over for you. No, you go ahead. You're right. So how did he buy this car? He mailed the money. How did he find it? I'd say it again. eBay Motors. Good. Right. He was on eBay Motors. And people that list things on eBay intend to do what? Sell them, yeah. So Arrow had listed this on eBay Motors. And this wasn't a case where he just made a bid and all of a sudden the car got delivered to him. Austin, what was the back and forth between Arrow and Mr. Greaves? Yeah, they talked about a warranty. He found their listing on eBay Motors, right? And then he reached out to do what? Anyone. Ask some questions about it, right? He found out about a warranty. He had some other questions answered. And as a result of the information that he got from going back and forth, he then made a bid based on what he'd learned, and he won. All right, what happened next? Who faxed? Go ahead, Austin.
Arrow faxed Greaves the purchaser agreement. Greaves signed it, faxed it back.
Right. Okay. And did Greaves go to Florida or did Arrow come to Georgia during any of this? No, it's all online or virtual, right? All right, how did Mr. Greaves get the car? Yeah, Arrow sent it to him, right? They didn't FedEx it to him. They didn't give it to another carrier. They delivered the car themselves to him in Georgia. All right, excellent. So this opinion that we're reading now is from what court? Says it at the top. Court of Appeals of Georgia, right. Is that a trial court or an appellate court? It's an appellate court, right. So is this where this case started out? No, it would have started out in a trial court. Your case tells you that was the state court of Cobb County, I think. So, to use our terminology correctly, plaintiff Gordon Greaves filed a lawsuit in a Georgia court against Arrow Toy Store, a Florida company. And what did he allege? What did he sue him for? Fraud. That's good, Jada. What else? There's another cause of action. Breach of contract and fraud. Very good. He sued them in state court for that. What's the first thing that Arrow did after they got sued? What was the first issue that they raised in the trial court?
They didn't have any ties to Georgia.
Good, Miss Miles. And because they didn't have any ties to Georgia, they're saying that they what? The court doesn't have jurisdiction over them. Excellent. You guys are doing great. All right, so Arrow raised their hand. We haven't had a trial yet. We hadn't gone before the judge or the jury. It's just so nice to conduct class in a construction zone. That sounds like it's right by Miss Miles. It made me lose my train of thought. So Arrow says, you don't have jurisdiction over us. We got to stop right here. The trial court heard the arguments about whether or not they should be subject to jurisdiction in Georgia, and the trial court decided what? Yeah, that they did have jurisdiction. Is that what you said?
Because they're in the appellate court.
They're in an appellate, but the trial court decided that there was jurisdiction.
Oh, that's right.
Yeah, you're right. Right. So Arrow then, instead of continuing on with the case at trial court, Arrow elects to appeal that decision. All right, so that's how we get to the appellate court. All right, what issue is before the appellate court? What's the one sentence question that the appellate court is being asked to decide? Not whether or not there was fraud, not whether there was breach of contract. Whether or not, say that again, Aiden? Whether or not Arrow should be subject to jurisdiction in a Georgia court. Excellent. That is the question that's before the appellate court. So Garrett and Garrett. One of you is going to represent Mr. Greaves. Which one wants to represent Mr. Greaves? You have on a Georgia shirt, so I feel like you should be representing the Georgia person, Mr. Greaves. All right, other Garrett is going to represent Arrow. All right, you can get help from your fellow attorneys in class, but you guys are the lead lawyers here, okay? And we'll start with Arrow. So what are all of the facts that support your position that you should not be subject to jurisdiction in Georgia? What are all the good facts for you? He's looking at co-counsel. Garrett, did you read this case? Not all the way. All right. Okay, even though you had extra time. All right, Garrett's co-counsel. Everybody over here, what are the good facts for y'all?
Keep it kind of broad, just minimal contact, obviously.
Minimal contact in what way, Drew?
Like, obviously, like we said, it was mostly online, so there's no, like, even physical company or a human capital or anything like that.
All right, so minimal contact in terms you're talking about broadly. We don't have an office here. We don't have people here. We don't have employees here. We're not incorporated here. And then specifically as it relates to Greaves, we only communicated on the internet. That was our only contact, right? What else? What are your other good facts? Aiden?
They also said that they only made 2 internet sales.
Okay, you have good co-counsel, Gary. They're doing good. You hired well. Only 2 sales over what, a 2-year period, maybe? All right. So, and as a percentage of overall sales, which Seth was saying earlier, pretty minuscule. I mean, less than 0.5% of our business is done in Georgia. All right, this is Arrow. All right, other Garrett, you're a lead counsel for Mr. Greaves. You think that Arrow should be subject to jurisdiction in Georgia. What facts support your position?
So even though it's like just a small percentage of the sale, it's still a pretty large sale.
Okay.
The 2 internet sales total $200,000.
Yep, 200,000 total. And what was this one for?
These were for.
No, I'm sorry. What was the Gordon? What did Greaves buy that car for?
What do you buy it for?
31,000. Yeah. Okay, that seems substantial to me. Keep going.
So like even though it's just a small percentage, they're still doing business
All right.
nationally. So it should be alive with broader customers.
Still doing business. All right. What else? What are some other good facts for you? Did Gordon just click a button and the car appeared?
No, they offered a service to ship.
Arrow brought the car to him in Georgia, correct? Yeah. And we'll see in our discussion later on how the court treats that. What else? What about the pre-purchase process supports jurisdiction in Georgia?
They conducted business negotiations with a Georgia resident.
They negotiated, right? It wasn't like he just clicked the button and bought something like, what is it on Amazon? Buy now? Buy it now? He asked questions about it. They went back and forth. How'd the contract get to Georgia? Got faxed into Georgia. Good. What else? Anybody got any other ones? Hey.
Greaves presented that at least 11 other people had submitted high bid on cars being offered.
Okay. Yeah, you say you only sold 2, but
11 other people.
we see where 11 other people were the highest bidders. So yeah, you might have only sold 2, but you're interacting with a lot more than 2 customers. So sorry, y'all. All right. Another we can do about it. All right, good. So that sets up where we are, the factual background. The court is then going to tell you what the law is that we're looking at. In this case, what's the law that's in question? What's the name of it? Say again? The long arm statute. There you go. The long arm statute in Georgia. And the long arm statute, this case quotes a good bit of it, but the pertinent part is paragraph 1. All right. A court of this state may exercise personal jurisdiction over a non-resident where the non-resident transacts any business in this state. This is a statute, right? The long arm statute. So where did it come from? What's the source of this law? Who passed the law? Statutes are created by legislative bodies. So this would have been passed by the Georgia legislature. Okay. Remember how we talked about statutes can sometimes be general, and then we need the courts to kind of interpret them and tell us what they mean. This is a great example. This statute just says you can have jurisdiction over non-residents if they transact any business in this state. What the hell does that mean, right? Well, we have court decisions from prior cases that have analyzed what transacting business in this state means, and we look at those. The court does that. It's going to look at some cases where they found that whatever the activity that was going on did not amount to transacting business. They're going to look at some cases where the activity did amount to transacting business, and then they're going to compare this case to those cases and see which one it's more like. Before they do that, they're going to take us on a little historical tour of how courts have treated transacting business in Georgia. So if you look at the bottom of page 2 where it says consideration of precedent, I took out a lot of the citations from this opinion just to save room, so it doesn't tell you what years these precedent cases were decided in, but you get enough context from them. And when it says in the early case, Coe versus Payne, that would have been like early 1900s. All right, so we're going all the way back there. And the court's going to tell you about that case, and it says that we interpreted the long-arm statute to exclude situations where a non-resident didn't solicit business in the state, just accepted a mail order in another state, and the only thing they did was deliver items here. That's a lot different. I mean, that is a different outcome than where we are now. And then they're going to take you through some cases where over time, the courts held that telephone or mail contact with an out-of-state defendant was not sufficient to establish purposeful activity. And then eventually, the court started saying, as commerce changed, that, you know what, we are going to start allowing long-arm jurisdiction over non-residents if they have placed something in the stream of commerce that ends up in Georgia. Think about placing it in the river of commerce. They put it in and it ends up floating down to Georgia somehow. Courts are saying that could be enough to support jurisdiction. Then we get all the way down to them talking about companies who just regularly do business over the internet and who send products to Georgia all the time, that has evolved to where that would be enough to support jurisdiction. So we went from back in the day when just getting a mail order and mailing something into Georgia was not enough to a thing where now, once you have pretty much mailed something into Georgia, if the lawsuit is a dispute over what you sent into the state, you could be subject to jurisdiction. Certainly it's come a long way. The court talks about the Butler case. You read about that? I like that case. That's the 12-year-old boy in Alabama who ordered a 12-pack from a beer distributor in Illinois, and they sent it to him via FedEx or UPS or US Mail or whatever. And the mom found out, and she sued the Illinois beer distributor in an Alabama court. And in that case, the Alabama court said, we're talking about $25 worth of beer. All they did was give it to FedEx, and FedEx took it into Alabama. Their website didn't solicit sales. I think the boy just looked up a number and called it and ordered beer somehow. I don't know how that went down. But you know, he was so excited when it came. Like, he was probably thinking, there's no way this is, there's no way this will work. And then, and then I guess then his mom got the beer and all went downhill. So then the court gets to this case. Are we more like the Butler case where it was just a tiny little $25 transaction? The website didn't have any interactiveness to it. A third-party carrier brought it in. Or are we more like the cases where internet vendors are advertising stuff for sale on interactive websites, and then they themselves deliver the goods to Georgia? Which one are we more like? The second one, right? So Garrett and Garrett, who won at the appeals level here? Which Garrett won? It was you. That is correct. That is correct. So that is an example sort of how not just the litigation system works, but how a court will think through analyzing a question of law. Remember, the trial courts would decide where Arrow does business, where they're incorporated, where Greaves is a resident. Issues of fact are all at the trial court level. At the appeals court level, they're not looking back at who's a resident of what. They're just saying, based on the facts before us, was the law applied correctly? Now, I will not ask you on a quiz specific questions about these precedent cases. I'm not getting that picky. I'm not going to, you won't see a question that says, in the case of Coe versus Payne, what happened? Or in the case of Butler, whatever, what happened? What you will see is questions like, how have courts changed their interpretation of long-arm jurisdiction over time? So I want you to appreciate the changes in the evolution of the way that courts have interpreted that law, more so than the specific cases along the way. Does that make sense to y'all? So don't get hung up reading those 2 pages of precedent and try to memorize what each case said. You already know from listening to the last 15 minutes of discussion how courts have changed their interpretation of long-arm jurisdiction over time. All right, good job on that case. That leads us, any questions on this case? All right, before we move on, Arrow lawyer Garrett, let's go back to that case for a second. And let's say that you could change the facts to help your client. Okay, you can change any of them that you want, however you want to do it. How would you and your team, what facts would you change that might alter the outcome?
You're saying like change something that happened?
Yeah.
I think it sounds like a big thing in the case was that we personally delivered it, right?
Yep.
So I would.
Your client.
Sound like a system
Yep.
to identify that we're not the ones that's personally delivering it.
Yeah, maybe you hired a third party to do it.
Well, yeah, because it's like you're looking here and saying that he like went to one of his, I guess, clients and so we don't have any business in Georgia, we don't have any stuff like that. But I guess us physically going in.
That was a big part of it, I think.
That would be part of it.
What do y'all think if, let's say that Arrow didn't deliver the car that they got a third party to do? Let me change that. Let's say that Greaves sent a friend down to pick it up for him and drive it back to Georgia. What do y'all, does that change the outcome of the case? Because you didn't, all right, what's your argument back on that, Garrett?
You're still selling to a Georgia, your product's still going to Georgia.
Okay. You're still placing that in the stream of commerce to Georgia, right? You're still selling to a Georgia resident. What else did you do during the lead up to the purchase? You still negotiated, right? To Autumn's point, you still negotiated and you reached out. You faxed the contract in. All right, Garrett, you can keep going. Change another fact that you think will help you. I'll give you a hint. Let's say that Gordon Greaves is on vacation in Panama City. He's a friend of Miss Daza's. He was down there with her. And over Labor Day weekend, what if he bought the car from the Arrow lot in Panama City instead of over eBay, over the internet?
He's at our place and everything. It's a customer.
You didn't do anything in Georgia then, right? No, he took it. He could be from anywhere, as far as you know. What do y'all think about that? Does that change the outcome? I mean, probably, yeah. I mean, he's got a lot better case. Yeah, when it says you're not licensed in Georgia, I wonder if that means to like open up a physical dealership or something. I don't know. Yeah, you didn't do anything. Right. In the new case, in the changed facts, you did nothing in Georgia. You didn't put it on eBay. You didn't send anything into Georgia contract-wise. You didn't even talk with a person in Georgia. Everything that happened in Florida. In that case, Greaves has probably got to go to Florida to sue Arrow. He always could have done that. Arrow would have had no jurisdictional defense to getting sued in Florida. But Greaves, of course, wanted to sue in Georgia where it's more convenient for him. Why might Georgia, Garrett, what other reasons could you think of why Mr. Greaves might have wanted to sue in Georgia rather than Florida, besides convenience?
I guess you can get more money out of it if they're in a different state.
Different laws apply to the
Possibly.
type of.
That's a good question. So it's possible that the laws would be more favorable in Georgia than Florida. That's a good point. I don't think there's a. I guess, Ms. Miles, the money difference would be if Georgia law allowed you to sue for more. Can't think of any off the top of my head, but yeah, you would look at the different laws. If the laws were more favorable in Florida, you might tell your client, hey, you need to go sue these people in Florida. What about being in the courtroom physically in Georgia in front of a jury? Where are those jurors from? Georgia. Would you rather make the argument to a Georgia jury, we have to protect our citizens from out-of-state fraudsters? That'd be a lot better for you. You'd be more uncomfortable in that situation, wouldn't you? You'd rather have the jury in Florida be like, yeah, we need to protect Florida businesses. I don't know that that's a great legal argument, but maybe is that in the back of a juror's mind? Yeah. Maybe they hate people from Georgia. Who knows? Maybe they have a huge beef. So those are other considerations that might go into it. All right, pull up your lecture outline for litigation. So litigation refers to a lawsuit and everything involved with the lawsuit. The conduct of the lawsuit, from the parties to the lawyers to the court to the judge to the jury, all of that wrapped together we refer to as litigation. Suing other people and getting sued. Litigation. I want to kind of walk you through the steps, the general steps of litigation. And there are myriad more steps to what I've laid out. But I want you to appreciate the general flow of a court case. All right, a court case starts when which party, the plaintiff or the defendant, who's going to start the case? The plaintiff. That's right. No defendant is going to raise their hand and ask to be sued. Right? The plaintiff starts the case by filing a complaint in whatever court has jurisdiction. The complaint has to lay out basic facts that tell the court, this is what the case is about. This is why you have jurisdiction. These are the laws that I believe have been broken or that support my argument. And this is what I want you to do. You don't have to prove your case in a complaint. You don't have to offer every piece of evidence you have. You just got to lay out enough for the court to determine that you're in the right place and that you actually have alleged something that, if it is true, would be a claim that the law would protect. Not making any judgments on it yet. If you file a complaint that, for instance, doesn't state what law you think applies to your case, then it could be dismissed. The court isn't going to do the work for the plaintiff. The plaintiff's got to tell the court the basics of the case. So pull up your sample complaint from your content module. All of these samples we're going over today are not on the quiz, but they are to illustrate what we're talking about. So this one, the sample complaint is a real complaint from a case in Atlanta, Fulton County, Georgia, where the plaintiff is alleging that they were overserved by the bar. So what you'll see is, if you look at the very, very top of the first page, in the state court of Fulton County, it tells us the court we're in. Then it tells us the parties. Brett Chance is the plaintiff. He's the one filing this case. BTW Atlanta which is the corporate name of the business that does business as Buckhead Saloon, is the defendant. That's the person getting sued. And then a complaint will break down. A complaint doesn't really do a narrative, like a long paragraph, long pages, long narrative of facts. It breaks them down into really small bites. So you'll see he starts out by saying, plaintiff is a citizen of Georgia. Defendant is a Georgia corporation. All right? That's telling the court right off the bat, you have jurisdiction over us because I'm a Georgia resident and I'm suing a Georgia corporation. So we don't have any jurisdiction questions here, at least when it comes to in-person jurisdiction. Then he goes on to state kind of what happened. On the evening of June 12, 2017, plaintiff was an invitee at Buckhead Saloon. Plaintiff was at all times well-behaved and paid his bill at the end of the evening. Next paragraph, he bought a bottle of tequila to take home. Paragraph 6, he walked out of there and he got the hell beaten out of him by some people who he claims were employees of Buckhead Saloon. All right. Now, flip all the way to the last page, and you'll see where it says, wherefore plaintiff prays. Plaintiff is telling the court what they want to happen. We want the defendants to get served with process. We want a trial by jury. We want a judgment in excess of $50,000. We want some punitive damages. We want our attorney's fees to be paid. And subsection G, anything else you want to do for us, Judge, we'll take that too. All right, that's the complaint. That gets served on the defendant by a sheriff or a process server. And then that defendant has a certain number of days to file their answer. Now, when Buckhead Saloon files their answer, they're going to go paragraph by paragraph, number by number, and they're going to respond to what the complaint says. So Buckhead Saloon's answer might say, paragraph 1, we admit that plaintiff was a resident of the state of Georgia. There's no dispute over that. Paragraph 2 says that we are a Georgia corporation. We admit that. That is true as well. We're not arguing over that. Paragraph 4. On the evening of June 12th, plaintiff was an invitee at Buckhead Saloon, was all times well behaved and paid his bill at the end of the evening. We might admit that. We might deny that. We might say we don't have enough information at this point on which to form a belief either way. But they're going to go through one by one and admit or deny or say they don't have enough information on each one. Again, this doesn't decide the case. Nothing about that decides the case. But it helps narrow down what the issues are. Okay? In the Arrow complaint, Greaves' complaint would have said, paragraph 1, plaintiff is a resident of the state of Georgia and subject to the jurisdiction of this court. Paragraph 2, Arrow Toy Store is a Florida corporation who transacts business in Georgia and is therefore subject to the jurisdiction of this court. In Arrow's answer on paragraph 1, they would have said, yeah, we admit that Gordon Greaves is a resident of Georgia. Paragraph 2, where they said that we were subject to jurisdiction of Georgia, we deny that. So we know right off the bat that jurisdiction is an issue that we don't agree on. Complaint and answer just kicks off the lawsuit, helps establish what it's about, helps establish what we agree on and what we don't agree on. The next phase of the lawsuit is very often the most important part, one of the most important parts. And it is one that if you take away nothing else from what you learn in this unit, I want you to take away the importance of discovery. Discovery is the process by which the parties obtain information from each other and from any other relevant sources. And we're going to break this down in pretty good detail. The system is set up so that we're not allowed to surprise or ambush the other party at court, for the most part. If the other side asks for information that is in your possession or in your ability to obtain, you got to give it to them. In a civil case, remember, we're not talking about the government being involved. But discovery also applies in criminal cases. If I get arrested and charged with murder, then I get to ask the state of Georgia to give me all of the evidence that they have that they believe is going to show that I'm guilty. They get to ask me to list for them all the people and witnesses and information that I have that I think exonerates me, would help find me not guilty. That's the discovery process. It lasts usually a minimum of 6 months. It can be extended in complex cases or if there are good reasons to keep going. But what we're going to focus on next is the different methods of discovery. How do we go about getting information from the other party or from other people who have relevant information? There are a bunch of different ways. Well, there are 3 ways that I want you to know about. One is interrogatories. One is requests for production of documents. And the other is depositions. These are all in your outline. I've given you samples of I think of each one or of most of them. So let's start out with interrogatories. Interrogatories is a written list of questions that one party sends to the other that the other has to answer in writing under oath. I think that a divorce case, while it's not business law, is a really good example to help you sort of understand discovery. Let's say that I represent the wife in a divorce case. All right. In divorce, what all is going to be at issue? Splitting up assets, right? Custody of kids, conduct of the parties, alimony, child support, things like that. So in my interrogatories, I might ask the other side in my written questions, hey, list for me every bank account that you had, Drew, during the marriage. Tell me the institution, tell me the account number, and tell me what you used it for, and tell me if it's still open. And tell me if you owned it with anybody else. Tell me what the current balance is. Give me a list, Autumn, of every username that you have on any social media platform. Instagram, Facebook, Snapchat, you name it. List for me, Jada, every phone number that you've had while you've been married. Every email address you've used. Okay? Mr. Clark, list for me every job that you have held during the marriage. List for me every source of income that you have now. How much is it a year? Where does it come from? Give me a list, Maria, of every person that you think has knowledge of anything having to do with this divorce. Tell me who they are, where they are, their phone number, and tell me what you think they know or what their relevance is to the case. You might list my mother. She has watched or helped us raise kids. She's been around us many times during the 10 years we've been married. That might be one, okay? Interrogatories, written list of questions that have to be answered under oath. Interrogatories are good in that they can help at the beginning of a case do some basic background work that might take longer if you were asking questions face to face, like we'll talk about in a second. Okay. The downside of interrogatories is that we're not asking these questions and getting answers in real time. I can't follow up immediately on what Maria says. She might give me an answer that I feel like I need to ask for further explanation. Okay, I can't really do that. I could send her another set of interrogatories, but that's very cumbersome and time consuming. But it's a good place to start. The second one I want you to, for a second, pull up I think you have some sample interrogatories. I want you to pull those up. Those are from a employment discrimination case. And I lost mine, so let me pull those back up. Somehow. Oh no. Okay, got them. If you scroll down to page, let's see where they start. There's a bunch of definitions and instructions. It's just lawyers being lawyers. You get all the way down to page 5, looks like. Complainants' interrogatories. Number 1, identify all persons answering or supplying information used in answering these interrogatories. Tell me everybody that helped you answer this. State the name, address, business telephone number of each person with personal knowledge regarding the facts and circumstances surrounding the happenings of the occurrences, referenced in the complaint. Basic beginning fact finding or information gathering, right? Then we can drill down from there and get more specific. A request for production of documents is the second type of discovery that I want you to be familiar with. It is very similar to interrogatories in that it is a written list of documents, photos, videos, statements, any hard copies of things that you think the other side or that they think is relevant that you want them to provide to you. So if my interrogatory says to Miss Upshaw, tell me every bank account that you've had during your marriage and what institution it is, what the number is, what the balance is, whether it's still open. My request for production of documents could say, for every account that you listed in your answer to number 1 in your interrogatories, produce for me the statements to those accounts for this time period. For every telephone number, Jada, that you listed, produce for me the statement, the monthly statement for that telephone number. For every job, Mr. Clark, every source of income that you say you have, give me your pay stub, your W-2, your 1099. Let me see your tax return. I want any documentation that goes along with that. When I said list for me, Maria, every person that you say has knowledge of this, I'm probably going to also ask you, produce for me every picture, video, screenshot that you believe is relevant to the case. All right? Request for production of documents. You can keep doing them. You might send me something and I might want to drill down further and say, oh, I see there's a transfer into this account from this account. Give me those statements. You can keep going on these. Yes, sir.
So are there like limitations to what you can?
So there are limitations. That is a great question. I'm glad you asked. There are limitations, but the scope of discovery is very broad. So the laws, every state has about the same law, and it'll say that you can do discovery on anything that might reasonably lead to the discovery of admissible evidence. And at the early onset of a case, that's really broad because we don't know what might lead to admissible evidence. Just because I get it from you in discovery doesn't mean I can use it at trial. So that's another limit on it. Okay? Using it at trial is a different question than you having to give it to me in discovery.
Yeah, because I was like wondering, like if like someone were to ask someone like to send them a certain something, and they didn't think it was relevant to the case, but the other side did.
So a discovery dispute. These happen all the time because lawyers, being pains in the asses that we are, love to play games. You didn't ask me for exactly that. I don't understand what you're asking. Can you be more specific? That's too general. The scope is too broad. It's irrelevant, right? Well, your lawyer's going to be like, you damn straight it's relevant, and here's how it's relevant. Then you go see the judge and say, Judge, we've got a discovery dispute. We asked for this. This was what they responded. The argument is over relevance. What do you say, Judge? And the judge will say, yeah, you got to give it to them, or no, you don't have to give it to them. Okay? Discovery is a game, but it's also not a game. It's a game in the sense that you get what you asked for. And it's not my job to try to guess what you're asking for or to guess what information you're going to want and give it to you. My job is to read what you asked for, figure out if we have anything that's responsive to that, and to give it to you. It's not a game in the sense that if I try to play games and we go see the judge is not going to be happy with any party who is playing word games or hiding the ball or being unfair. That's not a good look. It doesn't end well for that person. Y'all remember, the InfoWars guy? What's his name? Alex James. Is that right? Jones. So when he got sued by the parents of the kids at Sandy Hook Elementary for defamation, he had said that it was a hoax and that it didn't really happen. Y'all remember that? And then they sued him, and they asked for all kind of stuff from him in discovery. And his response in discovery was to give nothing, not to respond at all. And the judge in that case found that his failure to respond to discovery was in such bad faith that they went ahead and entered a judgment against him. In other words, they said, we're not even going to let you go to trial. You can't even play the pregame fairly. We're not going to let you get to the real game. That's very rare. I mean, I can't think of many, if any, more times where I'm sure it's happened, but that's very rare. But his defense was basically, do what you want to me. I'm not telling you anything. It's not going to go well for me if I do tell you. So how much more bad could it be if I don't? I don't think that was a great response because they ended up finding was he liable for like $1 billion? I mean, something huge. So discovery can be a game, but it's really not a game. Disputes would be settled by a judge. It's a great question. Just because you turn it over in discovery doesn't mean they can use it against you at trial. That's going to be a whole different analysis. All right, the third method of discovery that I want you to know is depositions. And this is going to kind of tie it together how all of it works. Depositions are when the lawyer for one side gets the other person that they want to depose or take the deposition from in a conference room with a court reporter there taking down, recording every word that's said, that is then transcribed into a written question and answer response, a book of everything that was said. It is under oath. The advantage of depositions is that you can follow up in real time. I don't like the answer you give me, Mr. Allen. I think that you are evading my question. You've been vague. I'm going to ask a follow-up on it. If I ask you what this account was for, and you're like, well, I use that for my business, then I can say, what business? What exactly did you use it for? Was it just business? Was it personal? If it's owned with another person, then if I learn that from interrogatories, I might say, who is that? Why were they on the account with you? What involvement did they have in the account? I can real time follow up and I can drill down. I might not want to spend my time on a deposition asking you, list me every bank account that you've ever had, what institution it is, what was the number, whether it's open or not. I already can get all that from you in the interrogatories. Then when I sit down to take your deposition, I can zero in on the stuff I want to ask about. That's a better use of my time. So general beginning questions I might want to do in interrogatories before I depose anybody. I really don't want to take the deposition of somebody first thing without doing any other discovery. I might want to wait and see who Maria lists in her interrogatories of all the people that she says are relevant then I can choose which ones I maybe want to go depose. I don't have to depose any of them, but I can if I want to. The downside of depositions are that they're expensive and lengthy, and I might be having to travel to another place where the witness is to depose them. Think about a medical malpractice case where a patient sues a doctor for screwing up a surgery. The patient is going to want to have witnesses that are experts in that kind of surgery who have reviewed all the medical records and can say, based on their years of experience and all their expertise, that that doctor screwed up. The doctor on his side is going to want to have an expert in that area review all the records and evidence and say that what? He did everything right. If I represent the patient and I ask the doctor, tell me everybody that's testifying for you, and he lists as an expert witness this doctor out of California, and I want to go depose that doctor, my ass got to go to California and take that deposition. And my client's got to pay for that. It's all that lawyer time, all the travel, all that. So it adds up. So you don't necessarily want to give interrogatories and requests for production documents, depositions to every single person who might be a witness. There's not enough time in the day for that. But you see how you can start out asking general questions that then you can either follow up with more questions, interrogatories, or you can follow up with in-person depositions. All right. The biggest takeaway that I want you to have from our discussion about discovery is this. In the business context, anything that you write in an email or a text, any memo you send out, any work product that you create, any research that you do, any letters that you write, those could all be subject to discovery requests, whether or not you're the defendant or not. Okay? Autumn, do you work for anybody? All right. Let's say that you work for X corporation. All right. You're an employee, you mind your own business, you've done nothing wrong. But your colleague who sits next to you has the same job as you, sues your employer for discrimination. Okay? And your colleague has alleged that the employer has done all these things. Well, then you might be a witness. You might have to give a deposition where their lawyer wants to put you under oath and ask you, hey, what all do you know about this? What'd you see? What did you hear? What evidence do you think exists on this? Or worse, I'm making this up on them because you wouldn't do this, but let's say that it's a discrimination case and they say that you're the one you're part of the problem. Now the discovery requests say, please produce every email that Autumn Cut Kelvin has ever written that mentions this employee. This ought to send shivers up your spine in a lot of ways. Show me ex-employee's browser history. Show me every text that they've sent, if you can capture that. Okay? You might not be the one who's done anything wrong, but you dang sure might have done something that could be subject to discoverable information that would involve you in the lawsuit. So whatever you write, say, text, email, all that is fair game in a lawsuit. That is fair game. That doesn't mean we need to walk around being like, well, before I send this email, let me think about whether or not somebody could get this in discovery. We don't have a crystal ball. We have no idea whether or not it would be relevant in a future lawsuit. But we do know, if we read back through it and we're like, don't know if I'd want somebody else to see that, then we might think twice about it. Okay? Not most of you, some of you raise your hands who's married or has been married. All right, me and Austin. The rest of you at some point likely will end up in a marriage, or the percentages say that you will. If you're in a divorce case, those lawyers are going to ask in discovery for all your personal stuff. All that's coming out. Your credit card statements that show, and I'm saying you hypothetically, not you, Austin. Credit card statements that show charges made in the Bahamas on a secret trip with the person we're having an affair with. Discoverable. Emails, discoverable. Texts, Snapchat. I can't tell you how much good evidence I got for my clients got for our case from social media. There is something in the brains of young males, or all males really, but young males, especially if they're in uniform, that tells them it is always a good idea to take pictures of my junk and send it to as many people as I can. I cannot tell you how many times somebody she'd be like, well, he's having an affair with someone. I'd be like, well, what proof do you have of that? Here's a stack of screenshots. And then you're like, okay, yeah, I got it. That kind of stuff gets put on the screen in a courtroom, ladies and gentlemen, for anybody to see. And courtrooms are public. And we laugh and all. I mean, I am telling you this in jest, but I'm also telling you this in seriousness because somebody today, not in this class, somebody today will send a picture of their junk to somebody else on social media. I can promise you it'll happen. And it'll happen on a work computer or a work phone. It never ends. And I was picking on young men. Women do it too. Men, in my experience, are more guilty of this. But I'm not picking on men necessarily versus women. All that's discoverable. This is a business law class, so I do want your takeaway to be that anything I do in the course of my employment could be subject to discovery requests, subject to me giving a deposition, subject to me being called to court to sit on the witness stand, raise my hand and swear that I will tell the truth, so help me God, and be asked questions point blank that I've got to answer. But I do want you to have the takeaway too that in your personal lives, the consequences can be just as bad, if not worse. All right, so that is the discovery process. On Thursday, I want to talk about alternative dispute resolution, which is the last part of your lecture outline. I have posted a fact pattern that I intended to get to today that I didn't. We'll talk about that on Thursday. And the purpose of that is to just illustrate the process, the litigation process, and also the discovery process. And then if we have time left over, I'll have some current events for you. For this week, you don't have any reading other than your key terms and your lecture outline. Any questions from anybody? All right, if you came in late, come let me know. I think I got everybody, but come let me know. Otherwise, I will see y'all Thursday. Got life lessons from Professor Tebow today. I got you, Keyshawn, I think. Let me see.
We don't have a quiz this week?
We didn't last week. We did, but then I canceled class on Thursday, and I decided just to combine last week's with this week's.
So I've been looking at it to see.
I'm sorry.
It's not posted.
It's not posted yet.
So
Last week's stuff's going to be with this week. It'll be due Monday.
So it's gonna be like when? You know,
Monday the
when
8th.
it's posted?
Oh, I'll post it after class on Thursday.
Okay.
Yep. Sorry about that. If I had class on Thursday, I would have posted it, and then y'all would have had it. But I didn't feel good about giving you because I hadn't covered everything. So, all right, I got you, Keyshawn. Davis, I got you. I got you, Carly.
Okay, thank you.
You go by Carly?
I go by Annabelle. It's my middle name.
You told me that.
It's okay.
All right, it's changed. I got it.
Thank you.
All right, you have perfect attendance. Soraya. All right.